All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. I am very glad to have our visitors with us here today. I am Judge Faruya. To my right is Judge Morse. To my left is Judge Weinsweig. And we are here today to discuss our case, number CV23-0789, Harianto versus the State of Arizona. We will hear oral argument today, and as part of that argument, the lawyers are going to present. They have 20 minutes per side. You do not have to use all of that time. You may reserve some of your time for rebuttal, but that will be on you to keep track of that time. The clock and the podium is for that purpose, and you will need to remind us if we are asking you that you would like to reserve some time. We'll try to respect that. We would advise everyone in the gallery that if you have a cell phone with you, please make sure that it is turned off at this time or set to silent. We don't want anything embarrassing happening. We have read the briefs. We have discussed this case in conference, and please bear that in mind in your presentations. And with that, counsel, you may proceed.
Did you know you were going to have an audience today?
Well, thanks for reminding me, Your Honor. May it please the Court, my name is David Abney. I'm here representing the plaintiff's appellants. I just started rereading the Odyssey, one of my favorite books, and every time Odysseus has to give a speech, Pallas Athena appears, makes him look like a god, and inspires him. I'll just settle for a little inspiration, frankly. It's an interesting appeal in one sense. We have a pretty solid expert on 911 dispatch operations. The trial court didn't think so, and my colleagues across the aisle don't think so. But he had a great deal of hands-on experience as a lieutenant, as a commander, in charge of 911 operations, overseeing them, watching them. And then as far as his practice as a teacher, professor at Glendale Community College, where they have a program for public dispatchers and others, police dispatchers and others, he was in charge of the curriculum and creating what they're supposed to do, all the details, the guidelines, protocols. So he has a great deal of practical hands-on experience.
Now, counsel, it remind me if I'm, or correct me if I'm misspeaking here though, but your expert never worked as a dispatcher, is that correct?
Correct.
Okay. And he never directly supervised a dispatcher in the course of dispatching, although he was in charge generally of the office, so he had command of the office, is that correct?
Correct. I think more than just general, he was specifically in charge at various points in his career of the 911 operations.
But there's
for the
nothing
police department.
I'm sorry.
No, I'm done.
Okay. But my point is that there's nothing in this record that talks about him going into a dispatching office and teaching dispatchers in the dispatch office how to be dispatchers.
Correct. Although he set up the curriculum at the community college on that subject and revised it. And as I said, he was in charge of the operations himself. He observed them. He was the one that was running the show various times. So that gives him enough experience. Now, what they're criticizing, and I think what the trial court was worried about was, well, is he the greatest police dispatcher expert in the world? Of course not. No, I don't even know who would be the greatest police dispatcher expert. But he has experience, and you don't have to have a PhD in police dispatchery or to have been a police dispatcher yourself in order to qualify as an expert based upon experience. It can be hands-on experience, it can be experience observing, it could be experience supervising, but he has enough. If they want to attack the weight and credibility, that's fine. That's something for the jury to decide. But the jury didn't get to decide. I mean, the rug was taken out from under him, and the case ended. Basically because, I think the main reason was because he was not regarded as an expert, and he should have been regarded as an expert. This is really a game of inches, hours, minutes, miles, all of these things that came together. The theory is that the police dispatcher, the 911 dispatcher, should have acted immediately to cross dispatch to make sure that, in this case it was Trooper Schmidt, was directed to the area where the one-way driver was posing a danger. And there was a gap there, 17-minute gap or so. The sad part is that Trooper Schmidt arrives at the scene of the collision seconds after it happened.
You don't know that.
He's what he testified to. I arrived there seconds after it happened.
My recollection, and I'm willing to be corrected, was that there was the testimony or the evidence was that he knew that it had happened by a certain time and that cars were backing up, but no one could say exactly definitively when the accident happened.
I believe, and I think I put in the record in the briefing a couple of times, cited to the record where he says, I arrived seconds after it happened. So assuming
But he was based upon just that the cars had started to back up, but he was unable to say, he didn't witness the accident, he could not have known when it actually happened.
Well, he testified I came seconds after it happened. And even if it was a couple minutes after it happened or 5 minutes after it happened, we still have that approximately 17-minute gap. We're asking the jury to make a reasonable inference here that if he had been vectored there, that he would have done what he was supposed to have done and what DPS indicated was supposed to happen, which was to intercept the one-way driver, wrong-way driver, and take effective action to protect other motorists in the area. So that's a reasonable inference to make.
And I don't dispute that. The question is, what is a reasonable action to protect motorists at that time? You would agree with me that it's different if you have a wrong-way driver and you have a police officer who's coming the right way and they visualize the wrong-way driver. That would prompt a number of countermeasures in one instance. But that's not what we had here. What we had here was we had an officer who was up coming from Camp Verde down to Sunset Point and had not visualized this driver. And so different countermeasures are called for in that respect. Would you agree with that?
Well, he hadn't seen the driver. Our theory is if he had been vectored to that area faster, he would have seen the driver.
Okay.
And then taken action to intercept.
And let's kind of hone in on this a little bit, because I have some familiarity with that stretch of road because I live in Flagstaff and my office is here. So I've driven this length quite a bit, and I saw your math in the brief. We're talking about crossing a period or a space of road that you would have to drive incredibly fast in order to make any kind of great difference.
Well,
so
yes.
Would that not be, so my question goes to the reasonableness of the inference that an officer who's charged with keeping motorists safe would drive at speeds exceeding 90 miles per hour in order to position himself to intercept timely.
Heck, I drive at speeds over 90 miles an hour just to get from point A to point
I don't know
B
you want to
fast.
say that in this.
Well, I apologize for that, but I think we've all done it. I mean, it's so easy to do. I mean, in a police intercept vehicle, you're going to be able to get up to high speed, and in an emergency like this, that's what you need to do. Jurors could say reasonable inference is he needed to get moving fast.
Well, his negligence is not at issue here.
No.
Okay, and he testified that he would have, if they'd called him 17 minutes earlier, he would have done exactly the same thing he did, which is initiated traffic break at the location that he was at.
Well, that's a lot of hypotheticals piling
No,
each
it's
other,
not a
saying that.
hypothetical, it's what he testified to.
Well, that was his hypothetical. What I would have done if this had happened and this had happened, but what?
So how do you overcome that and get to any level of causation?
Well, you overcome that by saying there's a gap here where he could have moved faster to get.
But he said he wouldn't have.
Well, that's his hypothetical. Jurors could say,
So
no.
the jurors are just supposed to speculate that he was lying and would have actually done something entirely different than what he said he would have done.
I don't think that's speculation. Jurors would have a right to infer that based upon having the extra time, it would have made a difference because he would have been on the scene in an area to protect these people with time to actually do something. That's a reasonable inference. And they could say,
What's your support for that?
well, they could say, well, we've got your testimony here that you wouldn't have done anything different. But
Is there a case that you can cite to me that says when the record evidence is, I would do this, that it's a reasonable inference to say he would not have done this?
I don't think I could find a specific case like that. It's just I submit it's a common sense proposition. If the witness says,
No, I will take issue with that. I don't see how that's common sense.
well, I'm not sure how common sense
I mean,
got into
you've
the
got no
argument.
evidence that training experience that this is something they would have been trained to do differently. He said, I would have done this. His negligence is not at issue. So I'm asking you to help me because I see this case all boils down to causation. And
He is saying, hypothetically, if this had happened, this is what I would have done. And jurors could say, well, hold on now. Suppose you'd had 15 extra minutes. Would you really have done the same thing? And reasonable jurors could say, maybe not. That's a reasonable inference, that you would not have done the exact same thing if you actually had the
jurors
time.
could just speculate that he would have done something different without any evidence to suggest that he would have.
Well, see, this is where
What evidence can you point to say he would have done something different?
evidence to point that he would have done something
That
different?
he would have done something different.
All I
than
can
what
say
he
it's
did.
a reasonable inference that he would have done something different if
From
he had
what
had the time.
Okay, inferring from what evidence? What is the evidence that you are making this inference from?
Well, see, his conclusion is based upon looking at things in a situation where he didn't have the time, and he is speculating what I would have done. Jurors could say that speculation is ridiculous. Well, we're going to take an inference that you would have done something different.
Well, what's the evidence for
it
that
has to be a
inference?
reasonable inference, doesn't it?
Well, yeah.
I'm
Which
sorry,
one?
I interrupted your points, Wick. I apologize.
What's the evidence for that inference? You would agree with me that the testimony that if this had happened, I would have conducted a traffic break. That's evidence, right?
Yes, that's his testimony.
So what is the counter evidence that would support your, in the record, that would support your argument? Evidence, not expert testimony.
Well, what we have is we have a question of time, and then we have inferences coming from the time. We know in the time that was there, based upon what the dispatcher did and did not do, there's a gap. We know that the officer testified that I arrived seconds after the crash. What would have been, could it have been different if there had been that extra time, 17 minutes, 15 minutes extra time? And the officer can't say, other than speculating, well, I would have done the same darn thing if I just had extra time. But in that extra time, you get to move faster. You get to interpose yourself between. You get to intercept if you can. You get to interpose yourself between him and other motorists. You get to protect people, and that gap is gone there. And the officer is speculating, I submit, about what I would have just done the same thing. It's an easy thing to say. But
It's not speculation. It is his statement that that is what I would have done.
I would have done. That is speculation. That's not what I did. It was what I would have done. I would have done the same darn thing. Would you now? If you'd actually had the 15
What
minutes.
evidence can you point to suggest he would have done something different?
Well, all I can say is that all he's saying, I'm speculating what I would have done.
Okay.
But I mean, by using those words, we're talking.
Did you present expert testimony that there's any other officer in a reasonable situation would have done something different?
Well, we're talking about what the jurors can infer. With the extra 15 minutes.
Jurors cannot just speculate on something without some evidentiary support.
Well, we're getting
You're
to a sort of.
asking him to say it's a reasonable inference that he's lying, but you've got to have some evidence to suggest that that a reasonable person would have done something different.
Well, we're getting into a bit of a word salad here. Speculation, inference. An inference is something based upon the facts. The facts are that you didn't have this extra time. If you had had the extra time, what can we reasonably infer?
Okay.
You would have done something different if you had just had the extra time. If you had been directed
Is there
properly.
any evidence that you can point to suggest, even if he had done what you suggested, he would have actually gone far enough to get ahead of your clients and stop the accident from happening?
Well, two things. Number one, it's up to the jury to infer what would have happened based upon the evidence in front of them. And second,
Based on
remember...
What theory of causation allows the jury just to infer that this might have turned out different?
Well, remember that he said, I got there seconds
Give
after...
me a case.
Remember, he said, I got there seconds after the crash.
Okay.
That was his opinion based upon everything he'd seen and heard about what happened.
Mm-hmm.
Now, earlier, that got dismissed as sort of, is that really
There's a long
speculation on
case
his...
here, and we're done on that.
But that's awfully strong direct evidence from him saying, I got there seconds after the crash, as opposed to, I would have just done the same thing,
So,
even if I had extra time. It comes down to a difference between speculation and inference, doesn't it?
I'm not sure. The inference you keep describing seems to be very speculative to me.
Well, see, that's the trouble. Jurors are allowed to make inferences based upon the facts presented to them.
What is the fact that they're allowed to make this inference based on?
The
Is there
fact
any
is
other evidence that other officers would have done what you're suggesting?
the evidence is the expert testimony that said the dispatcher should have acted immediately, notified him.
Dispatch. What is the evidence that the officer would have behaved differently than he said?
Well, the expert also went on to say that if he had just arrived there earlier, there would have been a difference in the outcome. But we're not faulting the officer for because that ship is past as far as what he did based upon what he had to deal with at the time. Based upon what he had to deal with, what are you going to do?
Are you challenging the credibility of the officer? Have you ever made that argument?
No.
That he was self-interested because...
No, well...
Okay, so you're not challenging...
Well, no, I think I made some comments about that he is making the comments the way he did, testifying the way he did because of his self-interest. But that's not what the thrust of my argument is, by any means.
Okay, so you're not challenging his credibility. You're just
No.
saying he's engaging in a hypothetical, even though it's his job, and you're asking him what you would have done in this situation rather than this situation, and we're supposed to intuit or infer that, I mean, we don't believe him, I guess, is kind of what you're telling us. Not to believe him either intentionally or because he just isn't thinking hard enough.
No, I'm saying that reasonable jurors could say, this is sort of doubtful. If you had this extra time, wouldn't you have done something different? Wouldn't you have gotten to the scene faster, wouldn't you have? I mean, you arrived there seconds after the crash. Give him 15 minutes. What's he going to do that 15 minutes? Read Time magazine and drink a cup of coffee? No, he's going to be speeding as fast as he can to get to where he can do the most good to protect motorists on the highway, including my clients.
Although he said he wouldn't, right?
Well, that's what he said, but reasonable jurors could say that's hogwash.
Is that what the operations manual says? Procedure is to drive over 90 miles an hour in order to get to an oncoming driver?
As opposed to stopping traffic there where you can hopefully save a bunch of people?
Well, as far as speeding, officers can speed in an emergency. There's statutes on that. You can ignore basically almost every traffic law if you want if you're speeding to an emergency. So he can go 120, and if I were in his shoes, I'd have gone 120.
I'm familiar with the statute, but
Okay.
what you're proposing there is acting reckless in order to stop recklessness. I mean, is that's not really jiving in my mind. We have speed laws for a reason, right? It's
Correct.
It's to make sure that people are safe. And
Correct.
And because if something happens, right, an accident at very high speeds produces catastrophic consequences.
It can.
Okay. In fact, that's what happened here.
Yes.
Okay, so what you're saying is that the standard is that this officer should have acted recklessly in order to position himself with enough time to stop this wrong-way driver.
No more reckless than a trained race car driver. Police officers can run red lights, they can run stop signs, they can exceed the speed limit whenever it's necessary in their professional judgment to get from point A to point B as fast as humanly possible.
Yes.
And here, he needed to get from point A to point B, and the fact that he arrived at point B seconds after the crash shows that he messed up. If he had just and he did it because of this dispatcher. If the dispatcher had given him 15 more minutes or 17 more minutes, whatever it was, he would have gotten there before the crash and would have been able to do something. At least reasonable jurists
Mr.
could
Abney.
infer that.
I'm hopefully going to ask a yes or no question. is there anything in our record that you can point to that says either training or standard of care or something says that this is how a normal officer would have behaved in this situation, the way you're suggesting, as opposed to just initiating a traffic break there when he got the call?
Assuming he had more time.
Okay, let me qualify. Phrase that way, no.
Okay, thank you.
But I wouldn't phrase it that way.
I imagine you would.
I would phrase it in a sense of what reasonable jurors can infer from the
I
facts.
see you have about a minute 45. Are you
I'd love to say that.
Okay.
Thank you, Your Honor.
Give him a minute 45.
Morning, everyone. Thank you for coming. May it please the court.
Hold on just 1 second. We're clocking. There we go. All right.
Okay.
May it please the court. Doug Northup and Taylor Burgoon representing the state. Plaintiffs' appellants raised 3 issues on this appeal. Whether there was gross negligence, summary judgment was appropriate, causation, and also the exclusion of the expert. On the first issue, there's a dispositive issue that plaintiffs have conceded, and that is they have never below argued against or tried to establish a standard of care, which this court has said time and again is required in a case like this. That's case dispositive of it. There's also no evidence from which a jury could conclude there was gross negligence. On the causation point that your honors were focusing on, there's really something that's important, and that is what lawyers say is not evidence. What counsel says about the seconds after argument is wrong. In the appendix of the appeal, appendix 176, 181, and 182, Trooper Schmidt said he was coming down.
Again, I'm sorry.
176, 181, and 182. Trooper Schmidt said he was coming down Sunset Curve and in the distance saw traffic backed up far out ahead of him, and that's when he called in. He knew there had to be an accident. On page 181, the question was asked, you don't know how many minutes after the actual crash you arrived? His answer was, I do not. And then he went on page 182, he said there was a mile of backup and I had to fight my way around traffic on the shoulder to get to the accident. And Mr. Harianto, a plaintiff, said it was 15 minutes after the accident when the first officer arrived.
So where does this seconds after the accident happened quote come from?
It's from counsel. It does not exist in the record.
Well, did it come in the form of counsel saying, would you agree it was seconds after? And the
No,
trooper
it's
said
not
yes?
it's in the arguments in the brief. The witnesses never were asked or said that.
Mr. Abney has been a regular litigant before this court, and I have utmost respect for him. So be very careful.
Your Honor,
you're very sure about that?
I am not attacking Mr. Abney at all, but he wasn't involved in the workup of this case and the trial court work at all. He's only involved in the appeal.
Okay.
So that's why I say it doesn't help for me to say the sky's blue and he says it's purple or whatever it is. That's why I'm citing you to the record, Your Honor.
Thank you.
Not my argument and not his argument. On causation, they essentially concede that under normal causation that they lose. They argue the loss of chance doctrine to try to get around that, has no applicability at all and doesn't apply. And then finally, you know.
Let me ask you a question about that. So let's say we agree with you on the lost chance doctrine. Is that it? Or do we still reach the gross negligence and the expert witness issues?
I'm sorry, Your Honor, I didn't hear you said, do we stop after what?
So let's say we would agree with you on the lost chance doctrine, that there was no evidence of an increased risk. Do we still reach the gross negligence and expert witness issue?
No, because if there's no evidence of causation to go to a jury, that's one of the 4 elements of the negligence claim. That's the end of it. And again, they don't argue under normal causation standards that any reasonable jury could find for them, and they couldn't, because the evidence, as Your Honors had honed in on, is unequivocal. When the call came out, Trooper Schmidt said, pursuant to my training, I'm going to stop the cars behind me. I cannot have cars at highway speed closing with a wrong-way driver, and no one knows where that wrong-way driver is. It's an evolving, fluid situation. I do a traffic block break, I stop traffic, then I slowly start moving toward the scene. That's what he did. And when he got over to the top of Sunset Point, he could see out in the distance it was too late. It was an unfortunate situation. But if you take plaintiff's theory to its extreme and you say the call should have come out 5 minutes or 10 minutes earlier, Trooper Schmidt said, I would have done exactly the same thing. I would never have sped up. And that would have made him even farther away from the accident than he was.
So what about your colleague's argument, though, that the jury could still infer, even with that testimony, could still infer something else would have happened?
Your Honor, as I believe Judge Morris was focusing on, inferences for a jury have to be based on evidence. They cannot be based on speculation. And there is no evidence at all. The only witness is Trooper Schmidt. And he said, I slowed down. Dr. Hines, in his report and in his deposition, said, I don't fault him for doing that. The Court of Appeals before, when we were here, didn't fault him for doing that. The only evidence in the case is if this call would have come out, he would have done exactly what he did. And that's not any speculation or any inference. That's what the trooper said in his deposition. The question was, if the call would have come out 5 minutes later, what you'd have done? Exactly the same thing. If it would have come out 10 minutes later, what would you have done? Exactly the same thing, making him that much farther and farther away from the collision.
Counsel, do you take issue with the math that was done in the brief, about distances and such?
Absolutely, Your Honor.
Okay.
First of all, that math was never disclosed. It was never part of the case until the response to our motion for summary judgment below.
And I don't think that was the argument that it was. I think they asked
No,
that
but
judicial
it was
notice be
brand,
taken.
it was brand new, right?
Okay.
And what's really ironic about this, Your Honors, you probably recall the argument before in the minute order that's not challenged here was that Trooper Schmidt was negligent because he slowed down and did a traffic break. Now they're saying, contrary to that decision and that ruling, which is law of the case, they said, no, actually he didn't slow down. He actually sped up. And they come up, I don't know where these numbers even come up with, because Dr. Hines in his deposition said, I'm not an accident reconstructionist. I don't do any kinds of calculations or anything like that. So I have no idea where they made that up. And it's also based, the whole problem with that premise is counsel bases that argument on this Schmidt got there seconds afterward, which is absolutely contrary to the record testimony that it was a number of minutes and no one knows how long it was.
Let's kind of move then off of that and let's visit about the conduct of the dispatcher, because we're talking about the dispatcher's negligence here. So was the dispatcher sitting idle during this? They
No.
mention like a 17-minute delay. So
No, we put in evidence in the record, Your Honor, that from CAD reports, the dispatchers were doing many things during this time. They were dispatching it to the DPS troopers. Trooper Sharp was at Anthem in the I-17. They were calling Maricopa County. They had City of Phoenix officers on the way. They contacted the Phoenix Air Unit. They contacted Yavapai County through the Flagstaff dispatch. They were asking, are there any officers anywhere? Yavapai County sent officers that direction. They were doing all kinds of tasks during this time, and they certainly weren't sitting idle. And these
in this call, the initial reports of the wrong way driver went to Phoenix.
Yes.
Because he was first spotted in that district.
He was south of Anthem Road in Phoenix. And when they called, it's undisputed in the record that Phoenix dispatch called Flagstaff dispatch when the driver was 12 to 14 miles south of the Yavapai County line, which is where the divisions change. And the only standard that Dr. Hines mentions is the DPS standing order with which he agrees the dispatcher complied, says when pursuit goes from one district to the other, transfer communications to that district. It was miles before that. And again, there's no evidence in the case that the dispatchers were doing anything other than their very best to deal with this situation. And it just happened. There was only one trooper who was conceivably in the area to do anything, and that was Schmidt. And we know what Schmidt did. He got the call. He did a traffic break. He stopped. He started proceeding. And unfortunately, the Hariantos were in between Trooper Schmidt and the wrong way driver.
Would this be a different case if there had been another trooper between the Hariantos?
Hard to say. I mean, one of the difficulties here is the fact that there's a trooper who can intercede. We all see it on the news all the time. How in the world do you stop someone who is drunk, or in this case, it was some kind of a medical issue, someone who gets on, passes do not enter, wrong way signs, and is driving, police cars flashing lights?
But let's say there had been a trooper pulled over, doing radar or whatever, between the Hariantos and the wrong way driver. Then it seems like it would be a very different case.
If the facts were such that you could say that trooper should have done a traffic break and the Hariantos would have been behind the traffic break or something like that, you might have a case there. I mean, it's hard without all the facts, but you might have a case there, but that's not what we have here.
And this one, I mean, and I know we get on whether it's an inference or speculation, but because we don't have a trooper between them, there's just no evidence of causation.
Exactly.
Even under lost chance doctrine, lost chance doctrine, as I read our cases anyway, says there has to be some affirmative act taken that then increases the risk. So even if we had this situation, let's say that the trooper had sped up and got there, I mean, it's still not, it didn't increase the risk of danger to the Hariantos.
Of course not. Like the one case, the Thompson case that we cited, it was where the person, they had a leg injury and the hospital stabilized him but moved into another hospital because he didn't have insurance or whatever, and the person lost their leg, and they said if you'd have done surgery instead of transferred him, there the court allowed that to go forward. But even in those cases, the Lowe's case says you have to still have evidence of substantiality on causation. There's none here.
Counsel, does the lost chance doctrine apply outside the med-mal area?
I don't believe there's any cases cited outside of that area, but I'm not prepared to tell you there aren't any that exist. But there's never been any of those cases cited. First of all, it was raised in the summary judgment here. I think it was in their initial disclosure statements or something like that. I'm not arguing a disclosure issue, but it's a new thing. But even under the cases, if you assumed it applied outside the med-mal context, it doesn't apply to a situation like this. As Judge Morse noted, the dispatcher didn't create the peril and then interrupt the sequence of events. She was doing her best to try to figure out how do you deal with a really bad situation when you really don't have, there just wasn't anybody there who could intervene. And the one point I don't want to forget about, though, Your Honors, is the standard of care issue. Forget about it. I mean, Dr. Hines, again, might be qualified in some areas of police practices. We submitted the notice of submitting demonstratives that we used with the trial court below, again, because what matters is what the witness said, not what I said they said or what counsel said they did. He might be qualified in some areas. He has zero qualifications in dispatch. But regardless of that, he could not establish, what's the standard that would require a dispatcher to call this ahead when she did? And we've cited to Your Honors the Sandoval case, which is right on point. The court said summary judgment's appropriate on standard of care when no reasonable jury could conclude there was a breach of an articulable or objectively measurable standard of care. The Penzone case, Sandoval, both affirmed summary judgment. The Mendoza versus State case, again, expert excluded for that reason. And they never even attempted to establish a standard of care. And Dr. Hines just said, that's just my opinion. That's not good enough. And that argument was not addressed below in the summary judgment proceeding. It's not addressed now, and it's conceded. That's another case dispositive issue aside from the causation. Where's the evidence that these dispatchers acted with this lawful and destructive spirit that the court talked about in the Badia case? That they knew that their conduct would not only create an unreasonable risk of bodily harm to others, but involves a high probability that will occur. There's nothing in that situation to make that kind of an allegation. And so, for those reasons, the summary...
Would you agree with me that where you have a wrong-way driver, though, that the chances of something happening that's catastrophic are real?
Absolutely.
Okay, and dispatchers would know about that?
This is a priority one call, the dispatcher testified. It is the highest level call that they deal with. They know it's serious, but so are DUI drivers. There are all kinds. They deal with those situations every single day.
In other words, they're aware of catastrophic consequences.
Right,
of their
but the
acts-
question
of their
is,
actions.
did they know that what they were doing was likely to result in these catastrophic consequences? Not just did they fall below a standard of care, and remember, if they can't establish a standard of care, which they don't, that won't support even a regular negligence case. This is gross negligence, and my point is, there's no evidence in the record from which a jury could conclude, again, they can infer things if it's based on evidence, that the jurors acted with that level of conduct, and we know that this court affirms summary judgment on qualified immunity all the time. The Walls case is a good example. There's no evidence of that at all. So that's reason number 3 that summary judgment was appropriate without even getting to the expert exclusion. And again, the one thing I did want to point out on this issue of spit, the argument they're trying to make now is completely contrary to what they argued before. It is completely contrary to the evidence, and it's completely contrary to even what their experts said. And another thing on causation, getting additional levels here, but their expert testified that if Schmidt had sped up, it's possible there might have been a different outcome. And we all know from the Graffiti Valenzuela case, possibilities don't get you to a jury on causation. It requires probabilities. So we keep going through, all these different issues. I wanted to address just real quickly on the expert exclusion. Again, summary judgment was appropriate regardless of the expert exclusion, but we are dealing with a situation of an expert who might very well be proper expert in some cases, but not this one. And the argument they made is kind of cagey, and that is, well, he was a deputy chief, and so he was over everything, so therefore he must be an expert. And if you think about that.
Counsel, it's your time and you can use however you want, but I thought you covered the expert exclusion and standard pretty well.
Okay, well, Your Honor, I am more than happy to sit down and shut up.
No, that wasn't my
No, and I know
suggestion.
you're not suggesting I do, but I really feel like we've exhausted, I mean, this case, there's no reasonable grounds for saying that the trial court abused discretion excluding the expert. If that's affirmed, case over. Standard of care, absolute dispositive. Gross negligence, absolute dispositive. Causation, absolute dispositive. So if Your Honors don't have any further question, I will not take up any more of your time.
Thank you, counsel.
Thank you.
Mr. Abney.
It's one of those days. Anyway, just a couple of points. The seconds evidence that I discussed with the court, index of record 220, page 3, paragraph 11. Index of record 220, page 3, paragraph 11. That's where I got that from.
Thank you, Mr. Abney.
As far as the math, Euclid came up with that stuff a long time ago, and you're allowed to use math, I think, in making an argument. There's nothing bad about that. The point about an increased risk of harm is if you do something that increases the risk of harm, then you're going to be liable for it. That just seems like a common sense, common law doctrine. The math here, in one sense, is also interesting when we talk about time. The first notice to the DPS was at 4:05 a.m. in the morning, and the dispatchers finally got a hold of Trooper Schmidt at 4:22 a.m. 5 minutes later, the crash. And then seconds after that, Trooper Schmidt arrives. It's uncomfortable math, it's uncomfortable timing, but our position is if he had just had some more time, he would indeed have done something different, and that when he is saying that, no, I would have just done the same thing, that is on his part, that is a speculation on his part. The jury is allowed to make some reasonable inferences here based upon the facts, the math, the distances, the emergency nature. I think they're allowed to infer that this is it's not the Maverick movie. There is a need for speed here, and there is a need for speed in a situation like that. You've got to move fast, and anybody would know that. Thank you very much for your time.
Thank you.
Thank you, counsel, for your argument. We will take this matter under advisement, and we will issue a decision in due course. The court now stands in recess.